Good morning. I'm Gary DeWaal, and this is Bridging the Week from May 20th to June 7th, and today is June 10th, 2019. In the past few weeks, a Canada-based social media company was sued by the Securities and Exchange Commission for conducting an unregistered securities offering to United States persons in connection with an initial coin offering of digital tokens. The firm previously asserted in a so-called Wells submission to the SEC that its crypto assets were not securities, but in any case, purchasers in its ICO would not have expected profits through the efforts of the firm and its agents, but rather solely through secondary market transactions. Separately, the Chicago Mercantile Exchange brought a disciplinary action against a member for liquidating large positions in post-trade settlement periods without considering the impact of such orders on market prices, while the National Futures Association proposed a major overhaul of its guidance on branch offices and guaranteed introducing brokers oversight. I just returned from the beautiful Rocky Mountains and now have to dig myself out of reams of paper on my desk. So I can start shoveling. Let's get started. The Securities and Exchange Commission filed a lawsuit against Kick Interactive Inc., claiming that from May through September 2017, the firm conducted an initial coin offering of 1 trillion KIN digital tokens without registering the crypto assets with the SEC as required by law. According to the SEC, investors who purchased KIN tokens made an investment of money in a common enterprise with Kick and with other investors and reasonably expected profits through the business and management activities of Kick and its agents. Kick is an Ontario, Canada-based company that developed and promoted a popular internet chat messaging service. The firm previously argued in a so-called Wells submission to the SEC that its KIN tokens were not securities, but in any case, purchasers of KIN tokens in the ICO did not expect profits through the effort of Kick and its agents. Rather, they expected profits through secondary market trading and the ordinary forces of supply and demand. This is a very important case where the SEC has meticulously laid out its theory and essential proof in a complaint, and the defendant, Kick, appears ready to challenge the essential core of the SEC's application of the landmark Supreme Court decision of SEC versus W.J. Howie to digital tokens and ICOs. Strap in for a bumpy ride. The Chicago Mercantile Exchange settled another action against the trader, Coda Easterday, for placing large orders in a relatively illiquid market where the orders deleteriously impacted market prices. CME claimed that on multiple occasions from July 5th through August 2nd, 2017, Mr. Easterday liquidated large positions in live cattle and feeder cattle futures contracts that resulted in, quote, significant and disruptive price movements, end of quote. Specifically, claimed CME, Mr. Easterday entered orders during the post-settlement trading period to offset positions he put on during regular trading hours. He did this, charge CME, quote, with reckless disregard for the adverse impact on the orderly conduct of trading, end of quote. According to CME, Mr. Easterday should have been aware of the potential impact of his orders on market prices because his order quantity was greater than the 5 visible levels of the order book during the post-settlement trading period. Mr. Easterday, a CME member, resolved the CME disciplinary action by agreeing to pay a fine of $30,000 and having his trading access to all CME Group exchanges suspended for 20 business days. Previously, in March 2017, Saxo Bank AS agreed to pay an aggregate fine of $190,000 to the Chicago Board of Trade and the CME to resolve 2 disciplinary actions brought against it for the way it liquidated future positions of its customers that were under-margined. According to the exchanges, on multiple dates between October 2014 and March 2015, Saxo employed a liquidation algorithm that automatically entered market orders for the entire amount of an under-margin customer's positions. The exchange said Saxo Bank did so without considering market conditions and therefore violated its disruptive trading practices rule. Persons entering orders on CME Group and other exchanges must be mindful of the potential impact of their orders on the marketplace and avoid actionable or non-actionable message that are likely to have a disruptive impact on the marketplace. This appears to be particularly the case where the same person or entity places similar type orders with similar deleterious impact on the market over multiple days. The Securities and Exchange Commission enacted a new regulation, Regulation Best Interest, to help ensure that broker-dealers and their salespersons act in the best interest of their retail customers when making recommendations for any securities transaction or investment strategy. Regulation Best Interest is controversial, and Commissioner Robert Jackson dissented from the SEC vote to pass it, saying that, quote, rather than requiring Wall Street to put investors first, today's rules retain a muddled standard that exposes millions of Americans to the cost of conflicted advice, end of quote. Chairman Jay Clayton, on the other hand, praised the new SEC initiatives, noting that Regulation Best Interest, quote, goes significantly beyond existing broker-dealer obligations, end of quote. And finally, the National Futures Association proposed updated guidance related to the supervision of branch offices by all members and relationships with guaranteed introducing brokers. Among other things, under NFA's proposal, member firms must adopt written policy and procedures designed to ensure that a formal due diligence review is undertaken before they establish a branch office or G-IB, and sets forth the manner in which they will exercise oversight of such entities. Although NFA's guidance endeavors to provide members with flexibility in designing their specific supervisory programs in light of differences in the quote-unquote size and complexity of member firm operations, the guidance sets forth minimum standards for all members. Importantly, NFA's revised guidance, like its existing guidance regarding supervision of branch offices and G-IBs, applies to all members, although provisions related to G-IBs are solely meaningful to FCMs and Forex dealer members. Accordingly, all members must review the revised guidance to assess which provisions might apply to them and to revise their policy and procedures to reflect new requirements. Moreover, when revising their policy and procedures, members should not solely cut and paste NFA's requirements, but adapt them specifically to their own business operations. All policy and procedures should be periodically reviewed and updated to reflect amended regulatory requirements and changed business operations. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website, www.bridgingtheweek.com. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.